Hi there, I'm Tim Dr. Hope Andrews. It's been over a year since my last video, wherever it is, one side or the other. Anyway, here's a quick update as to what's been happening since all of these Ocean's 11 Mark Collegian lawsuits against me, which, as you know, were filed against me just to punish me for not taking down my public forum website. Well, in the second case, I took all the money that I had and I hired a lawyer. He filed an anti-SLAPP motion. For those who don't know, a SLAPP is a strategic lawsuit against protected participation, like free speech. The judge denied the motion, claiming that the hundreds of posts on my website were not a matter of public interest. Really? This is where I ran out of money and have been acting as my own lawyer ever since. I believe that that was an error on her part. Hey, we all make mistakes. My legal research has indicated to me that the legislature enacted and said strongly that public interest is to be broadly construed. So armed with over a dozen legal citations supporting my position, I filed an appeal with the Court of Appeals. The opening brief, respondent's brief, and reply brief have all been filed. The court will hear, I'll try to say this straight. The court will hear oral argument on April 14th. So that's where we're at in the second case. In the third case, I filed an anti-SLAPP motion, and according to California Code of Civil Procedure, Section 425.16G, all discovery is stayed. That means no production of documents and no depositions. There can be an exception to this rule, but only if there's a noticed motion that specifies the specific discovery requested and shows good cause as to why there should be an exception to this rule. None of this was done. Nonetheless, the judge ordered that I had to go to a deposition and bring documents that would identify the employees and customers and the general public who posted on my public forum website. This is clearly contrary to what the law states. Well, because of that, I filed a motion to reconsider and went before the judge, at which time he said he would not even make a ruling on the motion until after a court-ordered mandatory settlement conference. Okay, so fine. I went to the settlement conference and was there from 8:30 in the morning till 5 p.m. Originally, they wanted me to pay and all this stuff, but anyway, it got negotiated down to where it wouldn't cost me 1 cent. My year-and-a-half-long nightmare would be over, and I wouldn't have to be spending 60 hours a week reading, researching, and writing the legal crap. That's a legal term, by the way. But there was a problem with the proposal. They wanted me to identify the posters. I negotiated, and they agreed that they would not fire any employee who posted on my public forum website, and that they would not sue the customers like they'd sued me. But the problem was that they said that they would ban any customer who posted on my site. I said in that case I would have to ask permission before I could, agree to that. So I left and sent emails to all the posters explaining the deal, and I got emails back from them saying Mark Collegian could not be trusted. While he might say he wouldn't fire the employees, he would create such a hostile work environment that they would quit. All I needed was one person to object to the deal. Believe me, I got dozens. So I rejected the deal. They then renoticed my deposition along with the production of documents that would identify the posters. I filed an ex parte request for a ruling on my motion for reconsideration, showing the court that it had no legal authority to order my deposition without a noticed motion, showing why they should have an exception to the no discovery rule of CCP 425.16G. My motion was denied. I then filed a petition for a writ of mandate with the Court of Appeals. That was denied. Pursuant to the court order, I went to my deposition, but I refused to identify the posters. After an hour and a half of being asked questions that had nothing to do with my anti-SLAPP motion, I left the deposition. Isn't this fun? They then filed a motion to compel and a request for sanctions for me leaving the deposition and not identifying the posters. Oh, joy, I get to file an opposition to another motion. My goodness. We went to court, and the judge ordered that I go to another deposition and that I identify the posters, and ordered that I pay just under $5,000 for my walking out of the deposition and refusing to identify the posters. Oh, joy again! I was not going to give them the information no matter what the judge said. My self-respect was worth more, but frankly I was a little nervous about going to jail for contempt of court. So I asked the judge what would happen if I just didn't show up. He said that they could get a default judgment against me, but no jail. Whew, boy, I was relieved. Cool. So I left the court. But now I had something that I could show in a writ of mandate that I didn't show before, and that was irreparable damages. So I filed a second petition for a writ of mandate, this time showing irreparable damages to the petitioner that I would suffer if the Court of Appeals did not correct the error of the trial court. I really thought I was going to win this one. I mean, just read the law. It says, to have an exception to the no discovery rule, there must be a noticed motion and a damn good reason for an exception. They didn't use the word damn. There was no noticed motion. I was denied the opportunity to object to their specified reason for the exception. This is called due process. I was basically denied due process, a right guaranteed to all citizens under the 14th Amendment of the Constitution to the United States of America. Surely the Court of Appeals would correct the trial court's error and grant my petition. I mean, really? Denied. Oh, joy. I had just spent another $1,000 for filing fees, copies, and gas to file the petition, not to mention the time to research, write it, and no reason was given as to why. So what do I do now? There's only one thing that can be done to correct the error of a trial court and the Court of Appeal, and that's to file a petition for review with the California Supreme Court. So I had to research that and learn how to do that. They want 13 copies bound on the left with a white cardstock in front and white cardstock in back. And they have to receive it before 10 calendar days. The cost of this, again, is about another $1,000. My research indicated to me that only 1 in 5,000 of these petitions ever even get heard. Not much of a chance. A big waste of time, a big waste of money. A person would have to be a complete idiot to spend 40 hours writing this petition, pay all the fees and the gas and the postage just to have the slimmest of chances. Okay, so I'm an idiot. I knew in my heart that I would regret not trying way more than trying and failing. So I did it. I got it done in just 4 days. True, they were long days, but I got it done. I knew I could have avoided all of this just by giving up the identities of the posters. But throwing those good people under the bus just to save myself is something that I could not and will not do. My self-respect is worth more. So, that's my update. Some weeks I've spent hundreds of hours reading, researching, and writing all this legal crap. It is crap. This is not how I want to be spending my life, but I have no choice at this point. If it wasn't for my poker, I couldn't even have covered the filing fees. I still don't have enough money to hire a lawyer. So, if you'd like to help me in this fight to protect the freedom of speech that's supposed to be guaranteed to all of us, you can do so in a bunch of different ways. Just check them out down here. Down here. If you would like to read some of the legal briefs that I've had to write, just to protect the posters' right to freedom of speech, check them out. Here are a link. Okay. So that's my story. If you'd like to comment on this, you can still do so on my public forum, which is still up, go figure. But you have to access it through a different way. All right, so that's it for now. And here's a big thank you to all of you guys out there who have donated in the past. It was greatly appreciated. And if you want to do it in the future, it'll be greatly appreciated again. Any help you guys can give me, I appreciate it. Tell your friends about this website. Maybe, they could spare $5 or $10. If enough of you guys get together, I might be able to hire a lawyer and not have to do this myself, although I am getting much, much better at it all the time. Anyway, thanks again. That's the end of my story. Donate if you want to. Tell other people about the fight that I'm fighting for freedom of speech. Maybe we could get some newspaper coverage. Maybe somebody can help me. In any event, that's my story. You guys have a great day, and see you later.